Greetings, myself Ruthresh Kumaran M. Second year LLB Hons student in School of Excellence in Law. Registration number H320113. My topic is Origin and Development of Industrial Design. With the global marketing and sales and rise in consumable goods, industrial design plays a very vital role as the physical appearance of the product, article or good is linked with the sales rate. As the trendy design tends to be sold much often than untrendy design, and the more appealing the product or article is, the faster the sales is occurred. As the consumers are trendy enough and choosy to choose specific designs which attracts them, which they like, which they prefer over another, which has created a major importance to protection of design in the current date, even in the previous years as well. As the history of industrial design in India was brought to us by our British colonizers. During the Industrial Revolution in the year 1787, the British enacted the first enactment for the Design Act, for the design, protection of design. As there was industrialization, many factories and many product and many consumable goods were being manufactured by them. In order to protect their design, their market value, their outlook, the appearance of their products, they enacted this design. And later in 1837 and 1842, they had various enactments. Finally, in the year 1911, we have the Indian Patent and Design Act, which was enacted by the British colonizers for India. And later on, by the virtue of TRIPS Agreement, Article 2526, which is present in Section 4 of the Part 2, we now have an enactment of our own, which is the Design Act 2000, and we also have a supporting rule, the design rules. Now, we have discussed about how the Design Act came into existence in India, but in an international perspective, the importance and protection of design was first pointed out and implemented in the Paris Convention in the year 1883, and later in Hughes Agreement 1925, they decided to protect the various elements were added, the various confusions were cleared, and in Laclos Agreement 1968, it was rediscussed and the protection was implemented. Right in the TRIPS Agreement, it was guaranteed. And every member in the TRIPS Agreement has to comply with this, due to which we now have the Design Act 2000, which was, enacted by our own parliament after the independence. Now, going back to what the design is, the industrial design is actually, the design is of four elements: the shape, configuration, patent, and ornamentality of the product itself. It is under this act we call it an article or a product. The final finish of the product is what is given more importance here. Upon registration of a new and an original product which is not previously published, the owner or the creator or the innovator of this design becomes the proprietor of the design. The time period is for 10 years. The protection is for 10 years upon registration, and the additional 5 years may be extended upon the request and the application and the preferred fee payment to be made to the board and the controller or the registrar. Now, to express about this development, it's not needless to say, as I have an example here. These two are a mouse. As you see, they might look similar, but they have a different design. The shape is slightly differs from one to another. This is what makes their marketability. This is what brings in the competition. The way this shape is. As you can observe, the outer appearance has totally different. Even though they serve the same purpose, they both are mouse for a computer, which can be used to access the computer. They have the same functions. They both have the same roles, things like click and left click. But the physical appearance makes them more appealing for the consumers to buy it. And the water bottle. This is a Tupperware bottle which used to be a standard design in my school life. It's like from my 5th standard or 6th standard. This shape used to be my dream goal, to buy a Tupperware bottle with this design. It's attractive at that point of time. Everyone in my school was crazy of Tupperware bottles because of the design. It was unique at that point of time. Now, though we have Signaware and other companies providing the same physical appearance, physical design, And still, this physical design was mine. I wanted to buy the same design, and even now today I still prefer Tupperware, but not because of the brand, but the shape. Even though I get it in another brands, I still prefer this because I like the shape. And even though the same design is there, I'm used to this company, so I'm still using Tupperware. This is a good example of how the marketing strategy works and how it is linked with the design. Section 2D of the Design Act 2000 expresses what design is, means as I already said, the feature of shape, configuration, pattern and color ornamentality of the good or the article or the product is what is more important and what is to be protected under this act. It can be 2D or 3D pattern or the design, but it should be manufacturable. There is no separate act for industrial design and for design. It is combined. Hence, this design act protects a manufacturable good outermost shell, the eye appealing thing or the outermost appearance that we get. Another example that I could bring up is a car. BMW car has a unique design. The unique, even though its speed, mileage, everything, the mechanical parts inside are totally different to another company, but the outside is more appealing, more attractive, and unique and it's different. In India, it's given only for a period of 10 years plus another 5 years to maximum of 15 years. But in other foreign countries, we have it to 20 to 25 years. India is much lenient, I believe, so that everyone can afford the same design. So that the luxury won't be available only to the rich people, but to a standardized lower class, middle class people can also afford the same design after some period of time, which has been much reduced. Preferably being from a normal standard of living, I would say that's helpful for me personally. And getting back to the topic, as I said, it should be manufacturable product. It should be industrially manufacturable. First point, and point number 2 is that I already discussed the shape, configuration, pattern, and ornamentality. And there should be original work. It should be unique. It should be different. It should be identifiably original and a new product which has been introduced. For example, I'd like to bring in the case Crocs USA versus Bata India. In this case, Crocs has put up an infringement case on Bata, stating that their design has been stolen by the competitor Bata. But the company claims that the design was previously published as before the date of registration. The Crocs company has used the design as a marketing and published it in their website. Thus, it's not covered under this act. The product is not covered, and the claim was being dismissed by the court. And in Rekita Private Company Limited versus Diva Apparels Private Limited, and this is a textual company where the patent was the plaintiff registered a patent for his company and claims that the opposite party has published their design work, but the opposite party, Diva Apparels, claims that this design has been published again and again, it's been manufactured again and again. Then they are not the owners or they are not the originators of the same design. It was printed a million times by other companies as well. Thus, if it is not an original work, there is not a new work for the article or the product, then it cannot be granted any protection under this act. And coming to the end of my presentation, I'd like to say that this Design Act is really linked to the marketability and manufacturability and sales strategy and marketing strategy of companies exactly to present their market and their brand. Personally, for an individual, this act need not be of a major importance, but to an organization, to a company, this is of a major importance as it links. It brings more customers for the company. Thus, the Design Act is majorly more important for any manufacturable industry. So the design, as we already stated, the shape, color, configuration, pattern, everything is more important. And the objective of this act is to give privilege. It's more similar to the Patent Act for monetary value, for financial value. If the originator or the creator of this design needs to be benefited for his work, effort and creation, intellectual creation, creation of his mind into physical form. Thus, this act protects the interest of the creator by granting him 10 years, even though the time span is a lot less, and it is not renewable. It's non-renewable. It's a one-time registration, and there is maximum of 15 years. This could be with extension. So thus, for this period of time, he can enjoy the financial and monetary value for this specific design. This is the main objective of this act. I believe this is the major objective of this act. And thank you for listening. And with this, I'd like to conclude my presentation. And before concluding it, I'd like to say, after knowing such act exists, my view on objects has changed. As everything I see, from pen to paper and everything, the shape and color texture. So I'm able to understand why the design act is more important in a competitive, marketable world of marketing and sales. Thank you.